Welcome to the Workology Podcast, a podcast for the disruptive workplace leader. Join host Jessica Miller-Merrill, founder of Workology.com, as she sits down and gets to the bottom of trends, tools, and case studies for the business leader, HR, and recruiting professional who is tired of the status quo. Now here's Jessica with this episode of Workology.
Have you heard the phrase, "Okay, boomer"? It seems to be everywhere on social media, on the mouth of our kids, and especially millennials. And recently, it's found its way to the workplace. Earlier this month, nationally recognized author, speaker, blogger, and expert on employment law, John Hyman, posted a really thoughtful discussion on LinkedIn. He asked, "Is okay boomer evidence of age discrimination?" The discussion that followed in this LinkedIn thread got my attention, and it tracked with other online communities, including one I'm a member of on Facebook that has 40,000 members. These are all job seekers and professionals in this Facebook group. The discussion that followed was really fascinating because John's question was based on a blog post that he wrote, which we'll include in the transcript of this podcast. I thought we should dive into this discussion even more. John talks about Chief Justice Roberts posing this question to a plaintiff's counsel during an oral argument. Now, this is the Supreme Court, so this is interesting, and it's rapidly turning into a hot button issue. I wanted to go straight to the source and talk to John on today's podcast. John, welcome to the Workology Podcast.
Okay, Jessica, let's go. It's good to be here. Thanks for having me.
Talk to people a little bit about your background before we dive into the topic today.
Yeah, so I am a management side employment lawyer. I've been representing companies in employment disputes for over 20 years. I litigate on behalf of companies in discrimination and other employment-related lawsuits. And then I also serve as what I call kind of outside in-house counsel for companies. So I'm the voice on the other end of the phone when they need a policy drafted, a handbook drafted, someone hired, someone fired, someone did something stupid at work, harassed somebody. I'm the voice of reason, telling them kind of where their employment law and HR legal pitfalls are and how to kind of navigate that issue hopefully without them getting sued.
That is the goal, right?
That's always the goal, and it's kind of counterproductive for me because I make way more money when companies get sued and come to me, but it's so much better off for companies to reach out to me ahead of time to make sure they're doing everything right and to stay out of court, because the only ones that make money in litigation, unfortunately, more often than not, are the lawyers.
Agreed. Well, let's go ahead and start at the beginning here, and let's talk about what led you to write the blog post on OK Boomer.
Yeah, so the Supreme Court last week heard oral argument in a case called Babb versus Wilkie, which usually when there's a Supreme Court case on an employment issue, it's on my radar. This one was not, because it's a really narrow, kind of not super exciting issue. It's what's the proper causation standard for a age discrimination plaintiff when the plaintiff is a federal sector employee. So not a super exciting or scintillating topic. And then I started reading all of these news reports about Chief Justice Roberts asking the plaintiff's lawyer about OK Boomer and whether OK Boomer could be evidence of age discrimination. And all of a sudden, this very not exciting case all of a sudden got on my radar. Real quick, it's an issue I've been following sort of closely for the last few months, because it's an issue that I think is really interesting. There was a guy a few months ago, and we can get deeper into this, but who suggested that it's like a super right-wing talk show host and columnist suggested that OK Boomer is no different, or OK Boomer for older people is no different than the N-word to Black people, and that really caught my attention. And so it's an issue that's been on my radar, and once it enters the Supreme Court lexicon, it all of a sudden is really on my radar. So it was something I was excited to finally get a chance to write about.
So I mentioned this at the beginning of the show, but I found your commentary on LinkedIn, but then I also was over in a Facebook group that has over 40,000 people. It's the Austin Digital Jobs Facebook group. And there was conversation about OK Boomer being workplace harassment. And it was so interesting to listen to hear all the snarky comments and then really honest comments, I think, from people who don't understand how maybe workplace discrimination works for a protected class or a group of people. They called boomers snowflakes, and there were lots of fun GIFs and memes and things that were thrown in there too. But that's why when I saw your conversation, I thought, oh man, I need to bring these two things together.
Yeah, and those snarky comments kind of, I don't know if they miss the point or make the case or both. So as to the question of whether OK Boomer can be evidence of workplace harassment, can create a hostile work environment, the answer, and I hate to give the stock lawyer answer, but it kind of depends. Workplace harassment or a hostile work environment can be created one of two ways. It's either offensive conduct, and it has to be offensive conduct based on a protected characteristic. So in this case, age, but think sex or race or national origin or religion, disability, a characteristic that the law protects from discrimination. And then it's the hostility, the comments, the conduct is either severe, that is, it's so ridiculously offensive that one utterance, one instance can be enough to alter the terms and conditions of employment and create a hostile work environment. So you think the noose that's hung up in the locker of an African-American employee, or a swastika drawn on the desk of a Jewish employee, or like a workplace sexual assault in a sex harassment case, so severe that one instance would be more than anybody should be expected to tolerate. Pervasive doesn't rise to that level of severity, but it happens over and over and over again, such that it gets to the point where it does impact the workplace, alter one's terms and conditions of employment. So that could be the offensive jokes that are told over and over again. It could be demeaning comments told repeatedly to targeted at members of one particular class or another, and that's the area where OK Boomer would fall. I think in this instance, I think context matters a lot. I don't think, and I strongly disagree with the guy who said that OK Boomer is the same thing as the N-word. It's not. It doesn't have the same level of vitriol. It doesn't have the same history of hostility. We're talking about like a months old meme, not a centuries old, loaded word of hatred. So I don't think that one employee saying to an older employee, one time or a couple of times, if they OK Boomer them, okay. And we'll get in a second as to how HR should react to that when the complaints come in. But if it happens over and over and over again, to where you really are, someone's being targeted and they're really being impacted by the repeated pervasiveness of it, that's when I think legally an employer who ignores that's going to have an issue.
It's interesting to me, the difference in responses, and you weren't part of the Facebook group I was in, but it's more millennial focused than I would say LinkedIn specifically, but it's also a place for kind of fun and snarky. But the LinkedIn commentary on your thread was professional, but it also garnered, I think, it left a lot of questions for people, like, is this a real thing? How did this happen? So I appreciate your response, because I think that others probably have similar questions.
Yeah, and the commentary, at least on my thread on LinkedIn, the commentary kind of fell into one of three broad categories. You had this is awful ageism and it never belongs in the workplace. You had I can't believe we're having this conversation. When is this going to stop? We can't say anything at work anymore. And we had the kind of middle of the road, which is kind of where I fall, which is, thanks for bringing this to our attention. Yeah, this can be evidence of ageism. It probably, if it's going to offend someone, it probably doesn't belong in the workplace. But whether it's illegal, I think it's going to depend on the particular circumstances of any given workplace and any given group of employees.
I feel like it's a similar response to the Me Too movement, when I've had some people who we're like, well, crap, I'm not going to be able to hug anyone anymore. Or I don't want to be alone at dinner with a woman because it might be misconstrued a certain way or in a work context or whatever. But I feel like this is still something that's important conversation to be having, because there is age discrimination and ageism. It does exist for people who are over 40 and are in a protected class.
Oh, it definitely exists for sure. They're very difficult cases to litigate. And I certainly wouldn't want a fact in one of my, in an age case that I'm defending, I wouldn't want okay boomer to be a fact. I have to have someone get on the witness stand and have to explain away. I think like the examples you brought up in response to Me Too, I think a lot of it depends on context. Like I'm a hugger by nature, but I'm not going to walk up and hug a female coworker unless I know 100% that she is going to be comfortable with that interaction. And I think the same holds true here. You have to know your audience, and you may be able. There may be a coworker, an older coworker, you may be able to joke with and okay boomer them, right? I got okay boomer by my daughter at dinner last week, and I'm not a boomer. I'm 46, but she was making a joke and it was funny and we all laughed. But you have to know your audience. And when you have someone that you're comfortable with and you can make the joke and it's going to be taken the right way, I think okay boomer may have its place in the workplace, in the right relationship and in the right interaction. I'm not the one who's going to say, no, you should never go to dinner alone with a female employee if you're a guy. And I'm not going to be the one who's going to say you should never joke around, an okay boomer somebody. But you got to know your audience, and you have to know where the line is, and you have to know that when someone calls you out for crossing that line, you have to know to stop and not keep pushing it, because it's when you know where that line is and you keep pushing it is where the conduct translates from innocuous workplace interaction to potential liability problem for the employer.
Let's take a reset. This is Jessica Miller Merrill, and you are listening to the Workology podcast sponsored by Workology. Today we're talking about workplace age discrimination with John Hyman.
Are you tired of putting your professional development on the back burner? It's time for you to invest in yourself with Upskill HR by Workology. We're a membership community focused on personal development for HR. Gain access to our elite community, training, coaching, and events. Learn more at upskillhr.com.
Well, this has been really interesting. And I'm thinking about maybe some advice that you could give to someone. So let's say that you're someone who is maybe the target of this kind of language. How should they handle it, especially if it continues? Like, how do you go to management and say, I feel like I'm being singled out. I feel like I'm being discriminated against. They keep sending me these memes or saying these things. How do employees address that with HR management?
Well, I think step one should be before you even get HR or management involved, is that if you're in a situation where you are comfortable going to the person that offended you and saying, hey, maybe you didn't realize this, but that meme you sent me or the okay boomer comment you made to me, I'm 60, I took offense by it. Do me a favor, can we try and keep this professional and not use language that I view as offensive and might be stereotypical of older people, right? That would be the first step, to have a professional interaction with the person who made the comment, because the odds are going to be that person didn't mean any offense by it, may not have been clued into the fact that it either was going to be offensive by it or that you were specifically going to be offended by it. And that, hey, by the way, can you please conversation with a coworker, that very well might end it right there before you even have to get management or HR involved. If that doesn't stop it, or let's say it's a manager that is okay boomering a subordinate and you're not comfortable because of the manager-subordinate relationship, you're not comfortable having that conversation with your manager or supervisor, or you don't have a good relationship with the person and you're just not comfortable going to that person to have that conversation, or you have the conversation and the conduct continues, that's the point where you need to get HR, management and or HR involved, and their response should be the same as their response to any report of workplace misconduct. That is to, number one, take it seriously. Number two, to investigate it. That is to talk to the complaining people, talk to the complaining employee, talk to the accused employee, talk to any witnesses, gather any relevant documents that might be out there. For example, if it was a meme, an OK Boomer meme, send an email, get a copy of the document so you know what you're talking about. Talk to all the parties involved. Make a rational business decision of business conclusion as to what actually happens, and then implement appropriate corrective action to reasonably ensure that it's not going to happen again. And that could look like any number of things depending on the employees involved, the severity of the misconduct, and the history of the accused employee. So it could be an admonishment, hey, there's a workplace, it's not the bar after work or the gym, we need to keep it professional. That kind of language isn't professional. It could be sending people to sensitivity training or harassment training. It could be a good reminder that you haven't done kind of company-wide training in a year or two, and this might be a good time to do it in general for everybody. It could be separating employees. It could be suspension. It could be termination. It depends on the severity of the misconduct and the prior history of the employee involved. The point is you have to do something. You can't ignore it. You can't bury your head in the sand as management or human resources. You can't bury your head in the sand and pretend like it never happened. You can't laugh it off and say, oh, so-and-so, you're being too sensitive. He was joking around. Don't take things so seriously. We're a congenial workplace. We don't create mountains out of molehills, and please don't do that. You certainly don't fire the employee who made the complaint, right? Everyone's protected from retaliation. They have the right to blow the whistle and understand they can do so without fear of reprisal or retaliation. So that in a 40,000 foot view is the rules of the road for collecting and responding to any complaint of harassment, but particularly here where someone is going to come and make a complaint about them being okay boomered.
One thing I really love that you're suggesting, if the individual's comfortable, is to talk to the person who made the original statement that you believe was inappropriate or was in bad taste. I think that sometimes we skip that step and we just go right to HR or go right to the manager or whoever, and we don't just sit down with that person and say, hey, I didn't like this. It's not something that makes me feel good. I think it's inappropriate for the workplace. Can you please stop this? Oftentimes the employee doesn't know that it's wrong or that it's making that person uncomfortable, and they don't realize that a line has been crossed. And it's a quick way to kind of set the boundaries and then open that line of communication.
Yeah, at some point we've lost the ability to be kind of conversational and human about things. And people are automatically taking things like up to 10, when sometimes you can start at 1 and end the problem right there. Because our goal as professionals dealing with these situations should always be to de-escalate as quickly and professionally as possible. We don't want to create a bigger problem out of a small problem. And sometimes when you go to HR, you get HR involved, the perception is escalation. Right, that's the perception of the employees involved. Is I can't believe you went to HR. You ratted me out. Now this is going to be my permanent file. It's going to follow me for the rest of my career here. You're ruining, you're ruining my career. You're whatever, and you're creating a bigger problem than what really exists. And so in a situation like this, we're not talking about a sexual assault in the workplace. We're not talking about a fist fight. We're not talking about some breach of confidence or some theft. This is a comment that maybe was meant as offensive, maybe was just innocuous and said in passing and meant no offense at all. And a simple one-on-one kind of person-to-person conversation in this instance, I think more often than not is going to stop the problem before it ever really becomes a problem.
The other thing that I like was your focus on treating this like any other employee investigation or complaint, regardless if it was a meme or a mention. It's just the same as if an employee made an inappropriate pass at an employee. As an HR leader, we go through our investigation, we interview all parties, we protect people from retaliation, we try to do our job, and then make advisements and suggestions on how the organization should move forward in regards to the offending or non-offending employee.
Yeah, and you do that for a couple of reasons. Number one, because it's what the law says you should do in investigating and remedying harassment. But number two, even for instances that might not rise to the level of like an actionable hostile work environment where the conduct's not going to result in the company getting sued, when HR ignores employee complaints, all that does is send a signal to employees that HR doesn't listen to us, management doesn't listen to us, we don't have their ear, so why bother making complaints at all because they're not going to do anything about it. When in reality, what you want to create is the exact opposite environment where management, HR's door is always open, you're going to take all complaints, you're going to treat them all seriously, and you're going to do something about it when and where you can, so that for all issues, even the small ones, so that when the big ones come up, employees are comfortable raising those complaints because they know they're going to be taken seriously and something's going to be done about it.
And I think that's true for creating a compassionate and inclusive workplace, which is
absolutely
really what we want.
Absolutely.
So one of the things a commenter said in the thread, and I'm going to read it here, is they said why they don't dispute the comment is ageist. They would ask, where does this end? How do we respond as HR leaders to employees who are like, I can't believe I am just getting in trouble for sending a meme about OK Boomer?
The answer, where does it end, is you leave off the second sentence of that comment. This might be ageist, period. That's where this conversation ends, because what we want to do is create workplace environments where everybody is comfortable coming to work, no matter their race, their age, their gender, their sexual orientation, their disability, their religion, their national origin, their veteran status, what have you. It should be a workplace that is, and you can expand that out even to categories that the law does not protect. In most, there are some state laws that differ, but in most places, how tall you are, how much you weigh, the color of your hair, what clothes you wear, whatever. You want to create a workplace environment that is inclusive for everybody. And if somebody is offended by the use of a phrase that they view as ageist, then that phrase doesn't belong in the workplace. The workplace isn't a locker room. It's not a playground. It's not a rec room. It's a place of business, whatever that business may be, and it should be treated as such. And if an employee is saying or doing something that is preventing another employee from getting their business done, then it doesn't belong in the workplace, period. And it's incumbent upon management to do something about that and set the right tone so that the business of that company can move forward productively.
I think this is a great opportunity because of just the conversation we've seen generated on your LinkedIn thread and then through your blog. This is a great opportunity for HR leaders to use the meme, which is kind of pop culture and is common among, I think, across the board in at least the United States, as an opportunity to have a conversation with managers and employees about workplace discrimination and ageism and the do's and don'ts for how we should all be able to work together.
Yeah, it's a great reminder. I talk to clients all the time, and one of the questions I'm always asking them is, when is the last time you did workplace harassment and equal employment opportunity training? The answer, more often than not, because most of my clients are small to mid-sized businesses that are always looking at kind of their bottom line and where they're spending their dollars. The answer sometimes is, we haven't done it in 2 years, we haven't done it in 3 years, we haven't done it in 5 years. Ideally, this is something that you should be doing both as part of your onboarding process with new employees and then on an annual basis for all for all current employees, because it sets the tone of the kind of behavior that you expect, the kind of work, the kind of inclusive workplace that you are. And then from a liability standpoint, the worst situation I want to be in as a lawyer is having to help my client craft an explanation when they're a defendant in a discrimination lawsuit or a harassment lawsuit, when they're asked the question at their deposition, when's the last time you did workplace harassment training? And if it's 2 years ago, 3 years ago, 5 years ago, why has it been that long? It's not a good place to be in if you're in the unfortunate situation of being sued. So if you want to look at it from a loss management standpoint, that's one way to look at it. The other way to look at it is just from our employees need to understand the type of workplace that we are, the type of respect that we expect in our workplace, and the type of culture that we hope to foster. And by doing this training on an annual basis, it's really the best way to help, aside from how you operate your business on a day-to-day basis, but to help reinforce the inclusive nature of the culture of your business.
Awesome, John. Well, thank you so much for taking the time to chat with us about this subject. Where can people go to learn more about you and what you do?
They can go to my blog, the ohioemployerlawblog.com. I publish Monday through Friday, almost every week, writing about everything having to do with the workplace laws from the management side of the table. They can find me on Twitter at John Hyman, JONHYMAN. They can find me on LinkedIn at Jonathan Hyman. And they can also find me at my law firm's website, meyersroman.com, MEYERSROMAN.com. I'm not hard to find. If you Googled like John Hyman employment lawyer, you're going to find all this stuff anyway. So I don't hide. I'm out there writing about this stuff all the time, and I'm happy to engage in conversations like this with just about anybody. So
awesome, John. Thank you.
Thanks, Jessica.
I highly recommend taking the time to read John's original blog post and the LinkedIn discussion thread. This has been a fascinating discussion. And now this Facebook group that I mentioned at the beginning, which is where I had some dialogue and some banter and conversation with some of these younger professionals who I felt like were not very thoughtful in their messaging. It was interesting to see. This one particular conversation in this group had over 84 replies and comments and memes and GIFs and all the things. It's interesting to see their interpretation and point of view and mine as an HR professional, and also hearing John's point of view as an employment attorney. It's interesting about how these next generation employees are treating boomers, and face it, Gen X, because we're not getting any younger. Also, let's remember that millennials are fast approaching 40. I can't believe it. These conversations are really a great example of the generational issues and differences that we're now facing in the workplace. I appreciate John's willingness to openly discuss the topic, share his thoughts, and kind of guide us in the right direction when it comes to workplace discrimination, investigations, and okay, boomer, is this a form of age discrimination? The answer is, it depends. Thank you for joining the Workology podcast, sponsored by Workology. This podcast is for the disruptive workplace leader who's tired of the status quo. This is Jessica Miller-Merrill. Until next time, you can visit workology.com to listen to previous podcast episodes.